No, I didn't proceed, but
there was no my lord, up until this stage, I have closed the meeting. We doing that by law, abiding by the side. And in the course of the schedule, I was going to tell you which are the bits I need to be doing. That one was not expected. Because I'm going to be going to you. The rules only permit me to swear and then sit back. Doing that abiding.
I understand. I think we can be curious whether
In support of the division, I don't have. In support of the division, I don't have.
So the first proposed issue by Mr. Kamere is whether the electoral commission conducts a by election for member of parliament for Kawaii Division North. In accordance with the law, and whether the non-compliance affected the result of the election in a substantial manner. So that capture what this slide that capture that.
I wrote for the first respondent, we have some more applicants, right? Yes, 6 more applicants, right? My Lord, Father, we give some information. Information of the second respondent. Which we seek rely on this petition. We requested for certified copies of declaration forms and a parking list, which we formally requested for the 24th of April and paid for
The second
the second installment. We also requested for certified copies of the water application, which was placed in the election. And until yesterday, we were informed that the secretary is yet to sign off. And in the previous we will request for some more time for purpose of finding those additional affidavits. In which case we'll be able to proceed with
also this by one the next week. I don't give you permission. The request by the first respondent, the commission was at 5 duties. I cannot decide I take that which is related. Next matter and man the next time. And being remanded by my colleague in the public court, I also calculated that in mind. That by Monday the judgment is completed and the person is going.
My lord, I hear the colleagues on the respondent side. But in my view, my lord, that should not stop us from shaping the matter, right? Because my colleague started by saying that the issues are statutory. So, my lord, the pleadings are in, majority of the affidavits are in, so we can schedule and finish. If my colleagues want time to file more affidavits, that's fine. That will then determine, my lord, if we need to make any rejoinders, those affidavits, but we can continue. Finish the schedule. When we come back, all affidavits are in, we just proceed to the trial.
Okay, Mr. Karoli, I think this is the first time on this because I saw the techniques that we find in another discussion.
Yes.
So this is giving them time to fight. Yeah, that is the half. So maybe we can set the limit. I think Service suggested Monday. So can we also have it on those on the first respondent by Monday.
My own Monday is not like 8 will be okay.
So we need like two more days. Yeah.
We'll bring issues and then we'll do it. Because we'll have a bring facts. I'll bring facts. Documents.
खड़े के chama dije sir.
After all, yeah, all what we want to do.
So the first respondent file in additional affidavits by Thursday, 8th of April. For the second respondent, file the same as undertaken by Monday. By Monday, the 5th of May.
My Lord, if you need to make any reminders, you can do so in the next 3 days.
For those that were outside,
My Lord, I was saying that when my colleagues file the respondents by 8, I would request for 2 more days to see if there are any reminders to make. They are affidavits. They are not. My Lord, I was saying that I'm done with affidavits in the form of the petition, but when they respond, I may need to review some aspects. Because my Lord, they may raise. My Lord, I will request that if they raise new matters in their affidavits, what affidavits they are filing in reply to mine, then I rejoin, my Lord, in just 2 days. By Saturday, I will be done. That's if there is need. If there is no need, I will not rejoin. I don't know if it's some other issue. Much of much.
This was the decision of the court in this advance request of exam. Counsel for the petitioner, I have informed the court that it has filed all the affidavits for the petitioner and that was ready to seal in the scheduling of the petition. In this respect, the court deems it that the petitioner has filed all the affidavit evidence he needs to support the petition. There will be no more affidavits filed by the petitioner.
Yes, the other issue I wanted to raise, my lord, was we've noted from the affidavits filed by the first respondent already that they have approached over witnesses and filed depositions purportedly retracting the evidence already made in support of the petition. Hello, we would like to raise, I don't know now or at a time opportune that the court may give us a preliminary objection. Those affidavits discovered. Lord, if you permit me, I can make the objection now or at any other time that you may allow me. If not now, my lord, my request is that my colleagues, the first respondent, stop approaching our witnesses and getting affidavits from them when they have already given us affidavits. Maybe my lord, I can make the objection now. Online.
I don't know that because I think the presidents are very clear. In the electoral petitions these days, it's in the front. I don't know why. Witnesses give evidence and they find, and it is the courts to determine who is saying when and what. Bring the thing we have provided. It's not a fact. Yes. And that has been the practice. I don't know the approaching, you will have maybe some problem, but giving a witness, giving to academics, courts have also made pronouncements. So to say that he wants to make to start the proceeding, in fact, that's the summary. That witness will have to take a stand and will determine which side or control any side, because justice has no side.
Your Lordship, maybe we are reading from different decisions and authorities of this court and the court of appeal that we have uphold that practice. And the court of appeal has several, more than 10 times, punished both the deponents and the advocates of waiver. I don't know which scripts you're reading from. The decisions we have. So my Lord, if you allow me, and my colleagues are ready to argue the people, we argue it now. We see their decisions, we see ours. Oblige you, my Lord.
This bill is granted to the petitioner, whereas the preliminary objection on the granting witnesses. So they will proceed.
I'm obliged. My Lord, by your leave, we have a prisoner way of law. Again, there's 3 affidavits filed by first respondent. These are the affidavits of Chamber Nathan Mwambuzi, the affidavit of Maumbe George William, Chamber Nathan Mwambuzi. Second affidavit, my Lord, is that of Maumbe George William. My Lord, Chamber Nathan and Maumbe George, on the 9th of April 2025, saw affidavits in support of the petition. So affidavits in support of the petition, which we filed in court. Chamber Nathan and Maumbe George William saw affidavits in support of the petition, which we filed in court and served upon the respondents. We are then subsequently, my Lord, approached by the first respondents council and Benny Mokasantari. And so affidavits in support of the first respondents answer. So affidavits in support of the first respondents answer. saying, my Lord, that that conduct of approaching our witnesses, that conduct of approaching our witnesses and making them recant our evidence is unlawful. It is detestable, my Lord. It is contrary to Rule 19 of the Advocates' Professional Conduct Regulations. My Lord, it means that those affidavits were obtained illegally, and this court and the Court of Appeal have frowned upon that kind of conduct. Why? Because it rebels against the tenets of the appeal. My Lord, the courts have held that if the first respondent found any issue with our affidavits, the course of action would be to wait for those witnesses in court and challenge their testimony by way. My Lord, the first case I have is Chintu Alex Brandon versus the Electoral Commission and William Moses. Court of Appeal. Chintu Alex Brandon versus EC and William Moses. I have one of my Lord. After reading it, I'll give it to you. Versus Electoral Commission and William Moses. I'll just read the holding, part of the holding of the Court of Appeal. It was held there, my Lord, that we wish to point out that the actions of the second respondent and his legal team in approaching the witnesses of the petitioner and obtaining affidavits from them was contrary to Rule 19, which not only renders counsel involved to disciplinary proceedings for professional misconduct, but ought to be sufficient ground for rejecting and striking out those affidavits for violating the tenets of a fair trial. Our rules would have required that the challenge to such evidence would only be by way of cross-examination to test the veracity of the evidence. An adverse side, my Lord, is prohibited from approaching witnesses for the other party with a view to induce them to testify against that other party. The second authority, my Lord, I have Lawrence Onama Obo. Lawrence Onama Obo versus Joseph Kasoro Okero and EC. Court of Appeal. Lawrence Onama Obo versus Joseph Kasoro Okero and EC. And there, the Court of Appeal held that, therefore, if counsel for the first respondent believed that the deponent had indeed been coerced in deponing an affidavit against him, the course of action that was available was to subject that witness to cross-examination to establish the veracity of his claim, including whether he understood the contents of the evidence. That authority I have, my Lord. The case of Akan Moses Okia versus Ariko Herbert and others. Akan Moses Okia versus Ariko Herbert and others. Court of Appeal. I don't hear the Court of Appeal tell that. In our view, it is imperative that actions taken in total disregard of the law must be sanctioned. It is therefore important that those affidavits that were made in complete disregard of the law ought to be struck out. The land trial judge ought to have struck out the second set of 12 affidavits sworn by persons who had already sworn affidavits in support of the petition. These persons were approached by the respondent's counsel and made to swear affidavits recanting their earlier sworn affidavits in favor of the petition. The respondent was barred by law from approaching or talking to these witnesses other than by way of cross-examination in courts of law. Fourth authority I have on this point, my lord, is the case of Nabukera Hussein Hanifa. Nabukera Hussein Hanifa versus Usasira Peace Kemuyu and East. Nabukera Hussein Hanifa versus Usasira Peace Kemuyu and EC. Court of Appeal, my lord. There, their lordship said, after quoting Rule 19 that I referred to earlier, that counsel for the first respondent should have followed the right procedure and challenge the adverse evidence through cross-examination. The trial judge ought to have considered the evidence of intimidation and strike out the evidence obtained legally. Questionable affidavits, my lord, cannot be said to have recanted the witness's earlier evidence properly deponed and are found as truthful by the same witnesses in their affidavits. We disagree with the trial judge to that extent and accordingly strike out those affidavits, attempting to recant the earlier evidence. Last point I have on this issue is Mbaju Jackson. Mbaju Jackson versus Tembo Gideon Mujungu. Mbaju Jackson versus Tembo Gideon Mujungu and EC. The lordships in the Court of Appeal, my lord, say, firstly, it is wrong and unprofessional for an opposite party to approach the witnesses of the other party, seeking to turn that person into the witnesses for the other side. Once that party is aware that such person is a witness for the other party, the only option available for him is to meet them in court and subject such witnesses to cross-examination. Any other course undermines the concept of a fair trial, where one party's witnesses are not safe from the machinations of the opposite party. Affidavits obtained this way should be struck out for infringing the right to a fair trial. Now, my lord, with those decisions, I think it is crystal clear from that jurisprudence that the affidavits purporting to recant our earlier affidavits in support of the petition should be struck out without question. Now, for Ben Mukasantale, my lord, the two purporting recanting affidavits state that he is the one who called them and took them to the respondent's counsel, the first respondent's counsel. That's what they say in the affidavits, those which are quoted in the counsel. They say, we were called by Ben, and taken to Mengo. Lord, it may please you to note from those affidavits that the first respondent's law firm is the one that drafted them, of course, among others. You go from the translation, it was from the first respondent's law firm himself.
Just to be clear, Ben Mukasantale,
yes.
You also swears recanting the
No, he did not. The point I make, my lord, is he procured the illegality. He participated in procuring this illegality I have just referred. And my lord, his punishment should be the same. That his affidavit should go. Lastly, my lord, for my colleagues who drew these affidavits and who ought to know the law, my lord, the punishment from the authorities I have given you, my lord, is twofold. What the courts have done is either punish them there and then, on the discretion of the court under section 24, the Advocates Act. That's what the courts have done in those authorities, is to refer the colleagues to law counsel. God has whether you can punish my colleagues here and now for that conduct. I refer to the decision of Shell Uganda Limited versus Mwema and Ngewa Advocates, Supreme Court. Decision of Shell Uganda Limited versus Mwema and Ngewa Advocates, Supreme Court. There, the Lordship said that you have the power, my Lord, to punish my colleagues here and now for that. In view of those brief arguments and the authorities I have relied on, I pray first that the affidavits of Cheba Nathan Mwanguzi, Maumbe Jojo William, and Ben Mukasa be struck off the record of court. Two, I Lord order my colleagues for the first respondent, or respondents generally, from approaching my witnesses, approaching my witnesses, and purporting to recant the evidence. The issue of their punishment is within the discretion and I leave it to you. That's all. The prayer is that this struggle of us, having procured the event, I refer to my Lord. I'm obliged.
Just to understand you, what you were saying, they struck out the
second set. No, my Lord. The approach is to strike out the second set. That's what the authority is.
The first set of affidavits
Remains for the execution. And the second set.
That's your prayer.
Yes, the second set is struck out. And that's what the courts have done in all protocols. They strike out the second set and leave the other one. And then by you, my Lord, the court have been saying that if that set remains, then the court subjects them to repeated tests during cross-examination. But the second set of affidavits goes.
This preliminary
that was the last thing. What about the last submission?
because the first bit gives to the punishment, and we had not. So my Lord, to punish all these lawyers. Excluding the punishment with respect to time, because we have authority including the presidential election, where we have had.
Only that you shouldn't focus so much on the punishment. Focus on the thrust of his submission was about striking out the second set of affidavits.
Yeah, my Lord,
So don't get lost with the punishment thing and forget the last problem.
my Lord, the issue is approaching. He has already expelled evidence. He has said you were approached by the party who committed the crime. But at the same time, he was saying, counsel for the first time in practice is beginning to collect witnesses. Now, if counsel is to approach or has been approaching witnesses, that changes the whole process. As far as I know, counsel does not approach. Witnesses are brought to, and he has also said they were brought by the carrier, and that is why they want to punish the carrier. But at the same time, he wants us.
Okay, so the prayer is for time.
For time.
Time to prepare your reply.
Yeah, you can do it written or you can come back.
I think you come back and Come back tomorrow.
Tomorrow is Friday.
No, Thursday, Friday. Friday. Friday will be second. Tomorrow is the one.
Every Monday. Friday we only have
My Lord, I am passing 10 lawyers. All of them cannot come with the
but
Friday.
they
Let's
all
come
have
with
they
the
all have the same.
Let's dispose that matter on Friday. Send next week, let's come back and handle it on Friday. I was saying that we can come back on Friday and finish that matter. They have 9 options or 10 options with an opportunity years. Really, I'm so many.
I know that there's only one day now, right? So it's not, and yes, it's passing many lawyers. However, there are also repercussions on each of them individually with prayer. So we don't just command the accommodation. Yeah.
Matters are not indicated. I also pray that money will be more available.
Before we is there any other matter that we need to take note of
Yes, my Lord.
before we adjourn for them to make a reply?
Yeah. I think from the way we have all filed our affidavits and my Lord has given directions, I think the issue of whether we proceed by way of affidavits is now settled. Whether we proceed, because my Lord, the last time round of elections, what we are saying we can proceed, we have all witness someone and kind of thing. But I think because we have all now filed affidavits, I think we assume that we have agreed to proceed in this petition by way of the listener.
So I agree with that one.
I don't understand. Is he saying that when we file up that's
No.
or there is provision for cross-examination?
What I'm saying, my Lord, from the jurisprudence in the 2021 round of election petitions, their lordships in the Court of Appeal say that a petition may proceed either by way of affidavits, therefore cross-examination, or normally as a civil case, where witnesses come and give evidence viva voce, or proceed by way of witness statements in accordance with amendments to CPR rules. So I'm saying that because now we have all filed affidavits, there should be no issue in future in the course of the trial about whether affidavits should be used.
So the first respondent, please reply, please, Monday at 9 a.m. Answer the queue. The number is going to adjourn to Monday, 5th of May, 9 a.m.
Much obliged.
What's that?
Hussein, what? What? Kyazagala ko.
Bagenda kwogera wabweru. Tugende tubalingize.
Nenda papo
Bagambye nti baagala amasembera maaso bayinza kuba tebaagala. Kitongole Julius. Mamira sana. Chamba mpaka ntukale. Watampata.
Bali my council otandise nga BBC tennatuuka.
Kusobola nayo tandika. Nga BBC tennatandika.
Council, sembereko Keri emabega. Sembere Keri emabega.
Tugende wano wansi. Kabitolake wano wansi.
Mujje wano council wansi awo. Batuwemu seconds asatu tutandike.
Well, the trial.
Second council, 1 second. Council, soko de makati kati na ukola de.
Chamba gisingire kawa.
Iya tujja
Aunga wote.
gende.
Gisingire.
Mike wants is simple.
Yes, the trial process, the election petition filed by the NRM to their candidate Nambi has commenced today. All preliminaries, leadings and responses are in. But the respondent, Honorable Naukola, will not proceed today with the matter since it has not yet been supplied the necessary materials to the Electoral Commission to support his answer. Actually, we need a register and other election materials. So that's why we could not proceed today with the hearing. And secondly, you know this is a matter which has a lot of illegalities. You find a matter where substantially the perpetrator of violence wants to depend on the same violence to impeach an election in the perpetrator's favor. The perpetrator of destroying election materials, ballots and the like, wants to use the same to defeat the voice of the people. So it will be an interesting matter. Luckily enough, the coerced witnesses to provide evidence to the petitioner have since jumped ship by coming to give us evidence, retracting their post evidence. That is an issue now for trial. And on Monday we are coming to determine how you treat such evidence of people who claim they were forced to provide evidence in support of the petition. So that is going to be a new twist in this matter on how such evidence is treated. That is why this matter has been adjourned to Monday for this court to determine on how to deal with evidence of people who are saying we were coerced to provide evidence by the petitioner. And they came to us saying we want to retract our evidence. That will be the only interesting bit on Monday. After that, we shall proceed with the trial. The respondents given a chance to look at the election materials that we requested for. We also be ready to proceed. We don't see it as a serious matter, and we pray this court will really find a reason to dismiss the petition. Monday we are arguing out the matter. The petitioners have made a case of their petitioners having their witnesses having recanted the evidence. We do not believe witnesses who come to us to say we are forced to give evidence and we push them away. At the end of the day, a trial election petition is an investigation. Election petitions, a trial is an investigation, and we believe it's proper that this court investigates the matter on whether these people were actually coerced or not, and that rests the case.
cannot deny any person from recanting. I think it's their right, especially when they give a background. We are coming for a response on Monday on that issue. And court will determine on that, on the way to proceed with such evidence. In any case, it is the evidence of the petitioner that will be affected. And because the petition is proved by the petitioner, not the respondent.
Tubadde mu kooti tubadde mu kooti olwaleero tubadde tuzze okukkaanya ku ngeri omusango ogenda otambulamu okukkaanya ku bujulizi n'engeri omulanguzi gy'agenda okukwata mu musango. Tusabye kooti abawabi bafeebye omusango gwa manjoolo, tusabye nti twetaaga okuteekayo obujulizi bw'abantu abala 6 ate nga tulina n'obujulizi bwe twasaba mu kakiiko k'ebyokulonda bwe tutannafuna okuli ne declaration of result forms eza polling station ezo omukyala Nambi zagambibwa okuba nti yawangula 12. Twagala ne regisita y'akakiiko konna n'ebirala ebyakosa mu kulonda twabisabye era twabisasulidde era tubiriize ate nga twagala byesigamaku n'akakiiko ebyokulonda nako kasadde kalina abajulizi abalala 6 befanya kuleeta. So kooti netugamba nti netuwa weekend na namba okulaba nga tuteekamu obujulizi bw'okuyitabiraire wabula abawaabi ne baddamu ne bateekayo okusaba nga bwomanyi nti omusango guno babagamba nti gwa manjoolo kati olw'okuba abajulizi abamu be baakozesa ate bamba ne bagamba abamu beegaana n'okwegaana obujulizi bwabwe teafi okukolangako kibanyiiza nnyo. Bagamba nti ate lwaki abajulizi baffe mwabatuukirira ate lwaki baawa obujulizi nga bwegaana obwaffe. So enteekayo okusaba nga tugamba nti waliwo emisango gya kooti gigamba nti obujulizi ekyasobola kikkirizibwa. So kooti netuwa olunaku lwa bbalaza okukomawo wano twogere okutaanya ku nsonga eyo oba obujulizi obwo obw'abantu abagamba nti baakakibwa oba byali bya bulimba biri bye baateekayo nga beegaana bye baakola mukyala Nambi yateekayo oba bukkirizibwa oba nedda. So ekyo ekigenda okubeera ku Mande ssaawa 3 naye ate nga tukyalina obudde ku nnamba okuteekayo obujulizi obulala fembi abaawuwaabi. So tujja kukomawo wano ate tulabe kooti kyesalawo n'okutulungamya paka omusango guno gunaagobebwa ate batusasula. Ekyo tugenda kyanukula kubanga tugenda kyanukula kunaku lwa bbalaza ndowooza olw'okwennaku zino bawulira nti gino kooti marshal esiba balooya nga kati baagala ndowooza ne kooti eno enkulu naye ekozesebwe okusiba balooya naye tujja kukyanukula.
Ansa y'ekyo musango gw'ebyokulonda tegwa gwaffe. Ensobi gyalowooza nti abo abajulizi babe. Musango gw'ebyokulonda mu mateeka ebeera investigation kuba kunoonyereza. Buli bujulizi bwonna obusobola okujja mu maaso ga kooti buleetebwa. Kyekimu ku bwemu obujulizi omuntu bw'aba agamba nti bankozesa ekirayiro nga bankase. Olw'okuba kuno kunoonyereza kooti nabo erina okutunuulira esalewo nti ono ddala Nambi yamukaka mu obujulizi oba nedda. Kati ekyo puliida talina waayingiriramu. Naye nakyo tubiredde okwewozaako okusalawo okulaba nti nno tukakasa kooti nti erina okuwuliriza ensonda zonna oli agezaako kunyigiriza bujulizi bwaffe obuddamu obujulizi bwe. Naye omukisa ogulumu election petitions obuvunaanyizibwa bubwe okuwa obujulizi obulaga nti akalulu kakola ki katambula bulungi.
Babadde basabuliti nga bagambye nti ensonga enkulu wandirinze bala tebajja cross examination naye mwekiraga nti mwabatuukirira.
Mu mateeka nonono bagambye
babadde basaitinga
looya abadde clear omu ku bajulizi be yagamba abajulizi banne tugende tukole ki era yabaleeta si balooya kibadde very clear. N'ekirala omujulizi ayinza obutajja mu kooti. Cross examination ebeera ku mujulizi azze mu kooti. Obuvunaanyizibwa buyita omujulizi mu kooti si bwa kooti. Oyinza n'okusaba okuleeta omujulizi eyo kooti n'ekola ki n'egaana. N'ekirala mwe mulisitinga nti bano tubaagala okubabuuza bano tubeetaaga. Oyinza okwesanga omuntu n'atajja mu kooti. Oyo omuntu bw'atajja mu kooti kitegeeza obujulizi bwe bwonna buggyibwa ki mu kooti. Batofunye mukisa mu cross examining.
Okay, mama. Nyabo.
Sabagira
Ayise. Yo.
sabi
Zigirako. Jako neyo gicheko.
Now, how we form reports. First responders. That they gave the petitioner that arena in support of the government. They gave
Wala
that they
bayibebuza
opposed the retracted
Wala bayibebuza
rival. In other words,
Oli kalundi wa loopu yanyanja. Kiri kyafanda ekivuga loopu. Wala bwe bagenda. Bakizudde nti taliwo. Tetulagala kwata wali.
the other side and ask them when you do that, this is the set of activities that are going to be practically